Hello, I'm Lisa Thornton. I've been the president of the Utah Prader-Willi Syndrome Association for the last 6 years, and I'm on the national board for Prader-Willi Syndrome. I am on the Family Links Council for the Utah Parent Center, and I'm also an attorney, and I help families complete their estate planning, especially families with children that have special needs. Most important, I'm a mom to 5 children. Kate, who you see on the screen, is my youngest, and she's 9, and she has Prader-Willi syndrome. You can see that she's quite the ham. I was driving to work thinking about what I would say, and this vivid image popped into my mind. I haven't thought about it for years. We were going to a swimming party for the kids with my daughter's syndrome, and it was my first summer after Kate was diagnosed with Prader-Willi syndrome. I was terrified to see what the kids looked like and the implications that it had for Kate, who was less than a year old. I was so afraid that it would change how I viewed her. When we got to the pool and walked in, I could see a man on the high dive, and he was standing out there about a foot from the edge of the board and visibly shaking. This was from the ground looking up to the high dive where he was standing, so he was shaking pretty hard if I could see him. He would inch himself out a bit, and then he would back up, and you could tell he was just terrified. I also couldn't help noticing the huge amounts of sagging skin all over his body, indicative of having lost a large amount of weight, which is common with the obesity problems with Prader-Willi syndrome. In past lives, I would have thought, poor guy, someone else will help him and just walk on. But for some reason, I couldn't do it. I made sure my husband had the other kids and handed the car seat holding Kate and the oxygen and the packs and everything to him. And then I climbed up the high dive and I talked with Robert. We talked gently for a minute, and finally, he said he really wanted to get off that board. So I reached out my hand to him, and he reached out and put his trembling hand in mine, and I can still remember what it felt like when we were grasping hands. We then edged ourselves across the board, me walking backwards and down the ladder to safety. I didn't think much about it at the time, but looking back over these last 8 years since that event, it really symbolizes to me what has happened. I don't especially like high places myself, and I was very uncomfortable up there, especially with a strange man who looked horrible to me and obviously had this hideous syndrome that my daughter had just been diagnosed with. But for some reason I swallowed all those fears, all that uneasiness, and just did what had to be done. And interestingly, my heart was filled with love and concern for the man whom I now know and love as Robert. So here's my message to you. I hope that each of you are reaching out to help. There are families in your communities that are crumbling and need the very help that you could provide. Work together with these families with your best efforts and help raise awareness and funds to help whatever group you're most closely associated with. I also want you to remember how blessed we are as parents to have these wonderful children in our families. We're meant to learn and grow from this experience, and I can tell you that our family is a completely different family because of our Kate. My children volunteer, they reach out, they know how to help. We are all more empathetic, and key to Kate's success is we have built a large community of caring for her because we reach out and help, and because we're willing to ask for help for us and for her. She walks onto the playground at her school, and there are "Hi, Kates" coming from everywhere. Work to build this for your child if you're not already doing so. The best way to do this is to hold fundraisers and awareness events, to volunteer, and to be out in the community. The kids in your neighborhood will love attending these events, and they'll love your family and your child, and they will be kind to her. As parents of children with special needs, we all wish, no, we all pray that our child with disabilities will live a long, happy, and enjoyable life, but that we will live at least one moment longer. As long as we are living, we tend to take good care of our children with hundreds of doctor's appointments and unending therapy, IEPs, figuring out group homes, and so forth. But what happens when we are gone? We go to extraordinary lengths while they are alive to see our children get every advantage, but parents of children with disabilities rarely plan well for the future of their children after the parents die. As parents of a child with disabilities, we need legal documents in place to protect us and to protect our child with disabilities. Your child should have a special needs trust established as soon as possible. It's also necessary, often, for families to secure guardianship over a child with disabilities who has reached the age of 18. It's recommended that each parent have a power of attorney, a medical directive, and a will. Parents may also want to consider a revocable trust as part of their estate planning. Finally, parents should consider a life care plan. This plan will outline the child's needs and likely expenses after the parent's death. This type of planning should address questions as to where the child will live, who will have a personal interest in the child, and how all of the child's financial, personal, emotional, and spiritual needs will be met. Some refer to this as a letter of intent. If you will email me, I will send you a Word document with many of the materials and forms that we have talked about today. My email is on this page of the presentation. If you can't afford an attorney to draft these documents, then perhaps you could fill out the form on the Word copy of the document and take it to an attorney in your area to review it. Find an attorney experienced in special needs planning. Most would do this for a few $100s rather than several thousand that many charge. I'm going to provide you with a template for a special needs trust. I will also give you language to include in your will to make sure the share going to your child with disabilities goes to her special needs trust. I can also give you the letter of intent or life care plan template that will prompt you with questions that you can answer regarding your child. Again, if you email me and request the documents, I will send them to you with instructions. Know that you will need to contact an attorney and have the attorney review your documents and finalize them. I'm just trying to give you a boost and hopefully save you some money and get in this essential legal planning completed. Keep in mind that this is a beginning point. You will do more estate planning throughout your life. Every time a life event occurs or enough time passes, you should revisit your legal plan and amend it if need be. So don't panic and don't view this as all set in stone for the rest of your lives. For example, don't worry and fret about who's going to be the guardian of your child to the point that you don't get the documents completed. Now let's go through these documents in a little more detail. First, to protect your child with disabilities, you should get a special needs trust set up as soon as possible. And you should seek guardianship of your child when he or she turns 18. Parents often struggle over how best to leave an inheritance to a child with disabilities. The child likely will not be able to support themselves, and the amount of money they will receive in government benefits will likely not allow them to live to the level they want. In many cases, if the child has not yet reached age 18, he or she will be unable to inherit directly. In other cases, parents will want to involve third parties, like other children or family members, and perhaps financial advisors to assist a child with disabilities to properly manage, invest, and apply funds for their benefit. It's really not advisable to leave money directly to an adult or minor child with disabilities. The child likely won't be able to properly manage, invest, and apply the funds, and the funds will interfere with or disqualify your child from receiving certain government and other assistance. If your child has more than $2,000 in his name, he would be disqualified from receiving SSI or Social Security income, Medicaid, and DSPD benefits. It is not advisable to leave the child's share of the estate in care of another adult child, intending that the child use the funds to provide for the care of the child with disabilities. While such planning may have the best of intentions, the sibling may misuse or squander the funds, or may suffer financial difficulties that will jeopardize the availability of your funds to your child with disabilities. Consider if the sibling gets divorced, who owns the money and how will a divorce court handle that money? Consider if the siblings try to apply for college financial aid. That money will be counted against them. In the event the caretaker sibling should pass away, perhaps with spouse and children, there would be confusion over who owns the funds that were left to the child with disabilities. For these and other reasons, it's better to clearly describe an appropriate estate plan in writing rather than rely on others to carry out the terms of your estate plan based on your discussions with them. And Medicaid knows about special needs trusts and they approve them, so you aren't doing yourself or your family a favor by trying to hide the money with a sibling. So a special needs trust is the safest, best way to financially care for your child with disabilities after you have died. Your child with disabilities needs a special needs trust set up to accomplish 3 goals. First, to prevent your child with disabilities from having more than $2,000 in her name. Second, to ensure that your child remains eligible for government benefits. And 3, to allow you to provide your child extra money each month to enrich her life, money that will supplement the bare minimum that the government should provide. A special needs trust is better to stand alone as its own document rather than be inside your will. A standalone special needs trust like the one I'm providing you allows other family members, such as grandparents, to contribute to your child's special needs trust, either through their own estate planning or with lifetime gifts. Also, this type of trust allows a caretaker of your child with disabilities to have instant access to funds rather than waiting for an often lengthy and expensive court process probating the will. So who should be the trustee of the special needs trust? The trustee is the person who will act in your shoes. He will be the person that decides what to spend your money on to benefit your child with special needs. Most parents choose a sibling to be the trustee. Is this the best choice? Maybe. But remember, every dollar that Jennifer trustee gives to take care of Kate with disabilities is a dollar that Jennifer trustee will not receive. Is that the best scenario? Would it be better to have a corporate trustee? Some people choose to have a different person handling the assets of the trust from the person that will be the guardian of your minor child with disabilities. Some choose to have that be the same person. There are pros and cons to both choices. The special needs trust for your child can be funded in various ways and can be funded during your life or upon your death. Here are some reasons why you would fund the special needs trust upon your death. 1, you don't have the money to fund the trust before your death. Many of us are in this boat. We're barely making it financially as it is. The second reason, you will have to file a separate tax return for the trust if it's funded during your lifetime, depending on the amount of interest made by the money invested in the trust. This would create additional expense and work that some want to avoid. Some reasons why you would fund a special needs trust during your lifetime. 1, you have plenty of money to meet your needs, and putting money into the trust will not jeopardize your personal financial security. 2, you wish to have the security of knowing there's a specific amount of money available for your child with disabilities. 3, you have a large estate and you're using strategies to reduce your estate tax liability by making gifts to the special needs trust. Your estate is safe from federal estate tax if it's not above the $5 million limit in 2012. Reason number 4, grandparents may want to convey some amount of money, either during life or at death, to assist a grandchild with special needs. 5, grandparents or other relatives or friends may want to reduce their taxable estate by making gifts of money to your child with disabilities. These gifts should be made to the special needs trust rather than the child in order to protect eligibility for government benefits. And the last reason, number 6, money or assets in the trust may provide protection from creditors. How you will fund this special needs trust for your child. If you don't figure that out, then you will just have an empty bucket to help your child. And the empty bucket is that special needs trust. You need to fill it up. During your life, you could commit savings to the trust, investments, donations from others, among other avenues. At death, your 401ks and various life insurance policies could be used to fund the trust. Parents may consider second-to-die life insurance policies. These fund upon the death of the second spouse. These policies have cheaper premiums. Term life policies are not always the best because they term or stop often when you're around 70 years old. And this is generally before most people die, and thus they will have no benefit in funding the trust for your child with disabilities. Whole life policies are an option to also consider. Some companies have provided calculators that help you determine how much money you will need to fund the special needs trust for your child so that your child can live to the level that you would hope. And I've listed some of these on the slide that you can see. One is from MetLife and one is from Merrill Lynch. In order to determine the funding amounts needed for the trust, consider making a timeline to determine when your child with disabilities will be eligible for which benefits and how much money you will need to care for your child and also provide for your own retirement. You're actually planning for 2 generations, for your own and for your child with disabilities. You will want to verify with your medical insurance as to when coverage stops with your child with disabilities. Some insurance plans cover children with disabilities for a longer period if they're given proper notice. For us, it is when Kate turns 26. This also coincides nicely with the exact year that Sid might potentially retire, and Sid is her father. When a spouse retires, becomes disabled, or dies, your child with disabilities will likely qualify for SSDI, This is a federal program like SSI that provides benefits to adults who have a disability that began before age 22. This pays more money per month than SSI and also allows your child to have Medicare insurance rather than Medicaid insurance. The rules are much easier to follow with SSDI benefits. Many believe Medicare insurance is also a better insurance benefit than Medicaid. The key to remember is this: how much money is the second spouse, or the one that's left after the first spouse dies, how much money is this spouse going to have to support herself and her child with special needs? Don't forget that you will need money to take care of yourself and your child with disabilities after your spouse dies. If you put all the life insurance on one spouse and he doesn't die first, what is he going to live on after the first spouse dies? Once your child with disabilities reaches 18 years, the law considers him an adult and you are no longer able to make decisions for him. You are no longer his legal guardian. Your child is presumed competent unless a court determines otherwise. This has many implications for you. For instance, insurance companies and physicians generally will no longer speak with you regarding the health issues of your child. They will only speak with your child. If your child runs away, many law enforcement agencies view your disabled child as an adult, and they will not search for your child as readily. If you get legal guardianship over your child, you can legally continue in the role as parent just as you have done for the first 18 years of your child's life. Many children with disabilities will need full guardianship when they turn 18 if they cannot provide for themselves and they can't meet their own basic needs. You should secure guardianship as close to the child's 18th birthday as possible. Utah requires that you hire an attorney to represent your child in the proceedings. You as a parent can represent yourselves or have an attorney who's different from your child's attorney represent you. If your 18-year-old with disabilities is competent and you don't get guardianship, then consider various options so you can help, including powers of attorney, HIPAA releases, medical powers of attorney, becoming a representative payee for SSI benefits. Your adult competent child with disabilities should have his or her own will, living will, health care directive, and medical power of attorney. When a disabled child turns 18, parents can apply for Social Security income, or SSI, for the child. The maximum benefit currently is $690 a month. Often SSI will be denied on the first try with our children, but parents should appeal the denial because the success rate of these appeals is very high and back payments are often awarded. Even if parents can afford to care for their child at age 18 and beyond, it is often a good idea to receive this SSI benefit. Use this money to provide the living expenses for your adult child and put the money of your own that you saved into your child's special needs trust, or use the money to help fund a life insurance policy on your life to help fund that special needs trust. Medicaid provides long-term medical care for adults and children with disabilities. When your child receives SSI, he will receive medical insurance through Medicaid for life. This will often be the only insurance for which your child can qualify after the age of about 26, depending on the rules of your private medical insurance. This is an enormous benefit to qualifying for SSI. Now we're going to address legal protection for parents. You should have a power of attorney, and it should be a durable power of attorney. This document names an individual to act on your behalf while you're still living. For example, if one spouse takes a job in another state and the other remains to finish up details, you will have the power to sign the documents for your spouse. Also, if you become disabled or incapacitated and cannot make decisions on your own regarding your financial affairs, if the power of attorney is durable, then that person named can still act for you financially. The medical directive names an individual to act on your behalf when you are unable to communicate your desires for medical treatment. When I'm helping people complete these forms, some will say jokingly, "Yeah, just pull the plug." But you may think a little harder about your decision on a medical directive when you have a disabled child relying upon you. Utah's medical directive is called the Utah Advanced Healthcare Directive. If you Google this term, you will be able to find a form online to complete. A will is a basic legal document that allows you to direct to whom your property will be distributed. The executor is named in your will, and this is the person that will administer your wishes upon your death. The will is the vehicle by which you will leave your assets to your children, grandchildren, charities, or other heirs. If you die without a will, you die intestate. Utah state law will then determine how your assets will be distributed. Under state law, if you die intestate or without a will, your child with disabilities will probably receive assets and would likely become ineligible for government benefits, such as SSI, Medicaid, and DSPD. If your child has more than $2,000 in their name, either in cash, stock, bank accounts, in any form, they will be disqualified from government benefits. If you and your spouse die with no will or other directive, your child will likely inherit part or all of your estate under state law. This would disqualify them from the money and medical insurance they might otherwise receive. Make sure that the language of your will or revocable trust does not leave anything directly to your child with disabilities. I will send an example of this language when you email me your request. In your will, you name a guardian for your minor child with disabilities and for your other minor children. If your children without disabilities are all over 18, you don't need to name a guardian in your will for them. You should already have a guardianship over your child with disabilities if that child is over 18 and needs a guardian. But in your will, you should name a successor guardian, assuming that you're currently the guardian for your child with disabilities who's over 18. If you don't name a guardian in your will, other family members can step forward and ask to be appointed, and a court would likely grant priority based upon relationship. For information's sake, you should know that even if you name a guardian in your will, that is only a nomination. If someone wishes to challenge the nomination, they could. Also note that just because you name a guardian in your will doesn't automatically make the guardian of your child with disabilities when you die, and the child with disabilities is 18 or over. There's a formal court process that must take place to make that happen, where the court issues letters of guardianship to the guardian to legally act as the guardian. Additionally, in your will, you need to determine if all your children will inherit equally. For example, will all receive a fifth share if there are 5 children? Or will you give a larger share or the entire estate to your child with disabilities through a special needs trust? To determine this, you should calculate what your child with disabilities will need in a trust to live at the standard of living you desire. Also note that the special needs trust that I will provide you leaves the remainder of whatever is left in the special needs trust to the siblings when your child with disabilities passes away. Many families choose to have a revocable trust along with a will that pours over the parent's asset into the trust upon death. This choice allows a family to avoid probate with the accompanying delay, court costs, and attorney fees. A revocable trust allows assets to pass automatically to your beneficiaries. The process is private rather than going through a public probate process through the courts. Another helpful document is the Life Care Plan or Letter of Intent. This letter is not a legal binding document, but is a crucial planning tool. This letter tells of your desires and concerns to caregivers after your death. It lists your child's personal information, the medical and financial profiles. It includes details about how you care for your child and what you want for your child. You are the most important person your child with disabilities has in his or her life, and you'll want to pass on as much information to that person who is going to care for your child should you pass away. I have a template that can serve as a guide to you as you complete this letter. For example, in mine, I would say, I sing the following song to get Kate to let me wash her hair. Or, I do the following to get her to take her medicine every night. I would also list her physicians, therapists, my life goals and dreams for my daughter, my religious wishes for her, etc. In conclusion, remember that this is not the last estate planning you will do. What I don't want you to do is leave this presentation and do nothing. Make a start to protect your child. Then revisit your plan and documents often. Good luck to you. I'm happy to talk with you anytime and wish you all the best in this journey that we all share.